Welcome to the virtual lunch. Today is Friday, February 4th, and this is virtual lunch number 493. Our guest today is Ross Guberman, the founder of Legal Writing Pro and the developer of BriefCatch. And this is part of our continuing series on superior legal writing with BriefCatch. But Ross, why don't we start? Just tell us about your background and really, let's start with the genesis of Legal Writing Pro.
I did practice for a little while, and then I did a bunch of things all at once. And one of those things was way back before remote work was trendy. I was editing briefs and writing briefs on the appellate side for a couple of firms, just as a project. An attorney very faithfully asked me to put together an informal class for the associates. I worked hard to put the class together and I did it. And then I found out about this niche. I didn't really understand it as a niche at the time. And I found out that there's this ecosystem, and I found out market rates were for seminars, and I said, I'm going to go for it. Back then, all you could do is send emails. So eventually I had a critical mass of clients, and then that's how Legal Writing Pro got started. I can't even take credit. It was really thanks to this partner at the firm who asked me to do the class. I started with people connected to my firm, also my law school. It was not easy back then to get names or titles, of course. There were no directories like there are today. So my big break, frankly, was I got a partner at Wilmington office of Skadden, took a liking to my approach and my emails. And he really did say it was just a phrase in the email that intrigued him. And then, to be perfectly blunt, once you have Skadden Arps as a client, life gets easier. You need something to make people feel comfortable, like the old nobody gets fired for hiring IBM. So also, I didn't really know what I was doing. I didn't even know which audience to target. Since I was an adjunct professor, I thought I'd start with summer associates, and that's what I did. So I probably would have given myself about 9 months, 12 months to see if it was going to take off. But I really loved it, even though it was hard the first year or two to get business. So I did enjoy it right off the bat. So I'd say I never looked back. Law firms were doing well. Professional development was coming onto its own. So I had a little bit of luck on the timing front too. There probably would have been a scenario where things had been a little bit worse, right? I hadn't done quite as well 12 months in, and I probably would have, maybe out of pride, pushed a little harder. But the way I looked at it is, if you're going to go into the training and development market, you're either going to make it or you're not. Either they like you or they don't. And if they like you at one firm, they're going to like you at the other firms. And you're going to either have business skills or you're not. So I don't think there would have been anything I could have really done. If I had not been getting any traction 9, 12 months in, I'm not sure, to be honest, what I could have changed. So maybe I would have thrown in the towel. It's hard to say. It's always easier to think about these things once they've worked. I read a book, I can't remember the title, it had Rainmaker in it somewhere. So it said that in the general consulting world, having a book gives you instant credibility. I still remember to this day, the book also said, it doesn't matter if anybody opens it, let alone reads it. You just need a book. So luckily, I wrote an article about the Chief Justice, John Roberts, but this is back when he was first put on the court. It was called 5 Ways to Write Like John Roberts. And I got very lucky because an editor at Oxford University Press found it, and then I got a book deal. So it's a lot easier to write a book when you have a book deal than to just write it all by yourself. And then I did notice a change in how things went once I had that book. It's exhilarating to have a book out in the sense that people actually did read it. That was the nice surprise. It did take off pretty quickly. The idea of publishing things excited me or intrigued me. So I responded to the markets. I made an attorney toolkit. I did a book on writing mentors. And then I did another big book for judges in response to demand, things that I thought people would appreciate. It's also really, really so much easier to write your second book. What I learned from the first book was more about me than the book content. So I was quite inefficient in writing the first book. It wasn't that I didn't know how to finish a book. It was just that the universe of great advocates was so huge. And back then it was really, really hard to track down motions and briefs on the internet, as people called it. I learned to better, more disciplined system for production. Because all those times I was writing all those books, I was working 80 hours a week. I was flying all around the world. I had to get my act together. One general concern with all lawyer training and development is whether things stick. Internally, you have all sorts of mentors and supervisors, and then you have the third-party consultants like me who fly in and do their thing. The person can be a great supervisor, be a good outside trainer, but do the lessons endure? So people do realize that about writing. People do sense that, hey, this is great, but how am I going to put it in practice? What happened was more and more attorneys would actually come up to me during the breaks or after to say, this is fantastic. There's no way I can remember all of it, let alone apply it. So could you make some macro? I'll look into what a macro is. How do you make a macro? And then I also thought the same. I mean, I took my cues from them. When you're actually working, how do you get all these tips and tricks and edits? When in real life, when you're working, your brain is multitasking, right? With the mother's insurance documents. I mean, how do you, when you're an attorney, get access to that content quickly and immediately while you're also trying to worry about your family, the deadlines, supervisors, clients? So that's why I decided to take the plunge and create BriefCatch first and then BriefCatch. Most of the value of BriefCatch consists of things that are specific to lawyers and judges. So there are some typos, certainly that Grammarly catches in legal work. There's some synonym suggestions that can be helpful too. But there are a lot of things that are very important for lawyers, but not important in regular writing, and the opposite. For example, if you say the court held, Grammarly is going to say, well, why do you keep saying held? Well, because that's what you call it, right? You don't just say the court decided and put in set in stone, right, or engraved on a tablet. I mean, you say held for held. So a lot of the value of BriefCatch, again, is specific, not just necessarily to lawyers and judges, but people writing about the law. So I have, either by choice or by request, veered away from the legal industry. I mean, I have clients, law firms. Sometimes they'll hire me to kind of impress one of the corporate clients, and I'll do something for the corporate employees. I've spoken to all those groups. I've spoken to accountants, forensic accountants. I've spoken to economics experts. It's great. I mean, it's lots of variety, but I'm glad that I did mostly focus on the law. By the same token, my original idea with BriefCatch when it first came out was maybe a little naive. I did actually think, oh, you know what? I'll say it's really good for everybody. Everybody can use BriefCatch, falling for that same trap, right? Thinking if you say it's for everybody, you'll get even better sales. And actually, in many ways, because of the overlap I mentioned, it probably does work outside the law too. It's probably different for different people and possibly for even different books. But the one thing that nobody tells you is you're the one who's going to have to figure out the stopping point. You might have this vision and then you get to work. You got to figure out, like, when am I going to be done? The reason that part went well for me, though, is before law school, I was doing a PhD, and I would see people just fester year after year with their dissertations. You can question it forever and want to make it better, but you have to figure out a reasonable endpoint. I wrote a book for transactional lawyers called Deal Struck with a really great fellow. He'd been a partner at a firm, was retiring around the time, named Gary Carl. And what I liked in particular was I'm always concerned for myself that I'm not in touch with reality, with day-to-day lawyers' actual work. So this guy had been a partner in a law firm for a long time. So although we were writing about something a little bit more cerebral, contract drafting just gave a lot of great perspective. Just because of all the APIs now, there's just incredible potential to get these various tools working together. I mean, that's probably why legal tech is doing great, right? Exciting sector, because there's just so much potential. I mean, even hyperlinks, if that really takes off, and it hasn't yet, I mean, some courts actually forbid hyperlinks, other courts are requiring them, right? So that tells you people can't figure it out, but that's going to spare people a lot of time wasted looking up the Blue Book citation. And there are very exciting things down the road, probably even just in the next year in 2022.
Ross Guberman, everybody. Thanks, of course, to BriefCatch for supporting this series on superior legal writing. Thanks, everyone. Have a great weekend.